Should you always object in court? Imagine sitting in a courtroom, hearing a question that feels unfair or hearsay that could harm your case. Do you jump in with an objection every time? Well, not necessarily. Objections are a powerful tool, but they need to be used wisely. An objection is a formal protest made during a trial to challenge evidence or questions that break the rules of evidence or court procedures. Its main goal is to keep inadmissible or damaging material out of the trial record. During the trial phase, objections happen when the opposing side asks a question or tries to introduce evidence you believe shouldn't be allowed. Common reasons for objections include relevance, hearsay, leading questions, or speculation. Relevance means the evidence doesn't relate to the case. Hearsay is testimony based on what someone else said outside the court, which is usually not allowed unless it falls under specific exceptions. Leading questions suggest the answer, which is often not permitted during direct examination. If an objection is made, the judge will decide whether to sustain it or overrule it. If the judge sustains it, the evidence or question is blocked. If overruled, it is allowed to stand. But here's the thing, objecting to everything can be a mistake. Constant objections can slow down the trial, annoy the judge or jury, and make you seem overly aggressive or uncooperative. Sometimes, even if a piece of evidence isn't perfect, it might not hurt your case. It could support your overall story or be harmless. Timing is also important. Objections should be made quickly and clearly, usually before the witness answers. A simple statement like objection relevance is enough in most cases. When you make an objection, stand respectfully, state objection, and briefly explain why. If the judge agrees, the evidence is excluded. If the judge disagrees, the trial continues with the evidence admitted. Remember, objections are meant to protect fairness and follow legal rules, but they should be used thoughtfully. Not every question or piece of evidence warrants an objection. Using them strategically can help your case without disrupting the flow of the trial. So, should you always object in court? No, but knowing when and how to object can make a big difference in the trial process.